All right. Hello, Kimberly, Santiago. Hello. Yessie, good to see you again. Here we are to talk about the power of three. Why the power of three? I work with small businesses, and what I have encountered through my experience is that there are three main topics that we need to assess when we talk about business. Formalizing your business, which is business formation. Are you going to become an LLC, a corporation, a nonprofit, a co-op? What are you going to be? The second step is, how are you going to do that? Through a contract. What kind of services do you offer? What kind of products do you offer? And what are the rules of your business? And the third one would be trademarks, right? You're building on a brand. What does it mean? And how can I reassure myself that my company has the rights on what they are creating and putting time on and investing on? So business formation, contract, and trademarks. Those are the three things we're going to talk about today. Let me click here. Really quickly, again, my name is Nicole Hetz. I'm an attorney here in Oregon. I'm also an attorney in Argentina, so I speak Spanish, and I can help in both ways. The way I see this happening in real life is that my clients that speak Spanish come to me, and I create kind of a two version of the contract, one in Spanish, one in English. And so everyone can understand exactly what's happening. A little bit about the firm, Rational Unicorn Legal Services. We offer 30 minutes free consultations. So always take advantage of that. Ask your questions, come with your notes. We are a pay-as-you-go kind of firm. We give you a project-based fee, so you will know exactly how to budget for it and how much it would cost. Again, we have experience with small businesses, nonprofits, artists, so take advantage of that 30-minute free consultation. The power of three, small business necessities. If I can quickly ask Kimberly, maybe Emilianet, if they can unmute themselves and tell me what kind of industry are you in? What do you do? Very quickly.
I've been a stay-at-home mom for the last 15 years, but I want to open a store that sells only earth-friendly products.
Fantastic.
Recording.
And maybe, I don't know if we can get some answers from Emilianet Santiago. Maybe not. We have Richard too.
Yes, we have a handful of people who are joining us as well.
Welcome everyone who's joining us. Thank you for connecting. We haven't spoken about anything important quite yet. This is the right time. We're just talking about what you do. If you can quickly unmute yourself, maybe Richard, Vanessa, Luis, and tell me what you do. No, not gonna work. We can leave that for the end. No worries, no worries. Okay, so the first step, right, business formation, and I will be quick. The first step is, what kind of entity do we want to form or be, and what kind of responsibilities do we want to have? Normally, we start in business as a sole proprietorship. What does that mean? You are the sole owner of a business. In Oregon, we call it sole proprietor, in Washington as well. But basically, you haven't incorporated your business anywhere. You haven't taken any steps for registration. Your business is associated with your social security number, and you are lending services or selling products under your own name. Nothing has happened. So you are responsible of all the profits, but you're responsible of all the debts as well. That's one of the things that we don't like about sole proprietorship, because there is no real separation between your personal assets and your business assets. So when you have trouble in business, things get messy and get a little bit intertwined. So what do we say when we see this, or someone who's serious in business? Let's form an LLC. What does it mean to have a limited liability company? That would be step number 2 in business, right? With an LLC, your personal assets are considered hands-off when it comes to business debt collection or other claims if your company is sued. In most cases, creditors cannot touch your home, your car, your personal bank account, so it will all be directed towards the LLC. It may have a cost at the beginning, a small investment to make this happen, but in the future, if you're serious about your business, it might be convenient to prevent anything from happening and registering as a separate entity, separate business than your social security number. You will see that now you will be associated with an EIN number and you will pay your taxes separately. And hopefully you will work with an accountant or CPA who would actually teach you how to take advantage of business expenses, tax deductible items. Maybe you work from home and you can deduct that office space from your taxes. Maybe you don't work from home and need a car to get to that office. Well, maybe that gas can be deducted. So talk to a CPA and talk to a lawyer. You always want those 2 people in your corner. So a little bit of like advantages and disadvantages. The advantages, of course, is the liability protection that we all know of. They are more informal than, let's say, nonprofits or corporations, where we hear about shareholders and stocks and a board of directors and kind of losing control of your own business. Those are very different than what we're talking about here. The LLC allows new small investments. Let's say you start the LLC as a single member, but tomorrow you want to become a partnership. The LLC is easy because you distribute membership units. So you're like, okay, I will sell you 50% of my business. And that's a clean process, right? Very easy. The disadvantages, well, it can be harder to obtain credit, raise capital when we are comparing them to a corporation, right? That's when we hear about shareholders, stock market, and bigger things. If you were looking for an angel investor, right? Someone in venture capital with millions of dollars, the LLC wouldn't be for you. The transferability restrictions, we always talk about this. When we form a company, and let's say it's a partnership, we want an agreement between partners saying how the rules of the business are going to work and how that relationship is going to work. And let's also plan for the day that one of you may want to exit that partnership. So that's an important conversation to have when you are in a partnership. We talked about this. We don't need to go even further about the differences between a sole prop versus an LLC. The main question I always get here is, when am I ready to take this step? When do I know I'm serious about the business? I've been doing this thing for a little bit. I kind of make money, but I don't know if I want to invest the money. Well, the answer is always, it depends, sadly. If you are putting yourself in commerce with your personal name out there and you have some liability, meaning someone could potentially sue you because they didn't like the way you performed that job, we want to protect your car. We want to protect your house. We want to separate business from personal life. And that's what the LLC does. So if you're ready, if you are serious about what you're doing, you've kind of invested some money and you have budgeted like $1,000 for expenses, startup cost, take the step and get your documents in a row and get that business bank account and have your things separated. That would be the best advice I can give you. Step number 2, client service agreements. What is it? Why do I need one? And what kind of provisions should I include? So I'm going to talk about the most important considerations when we think about this kind of agreement. Please know I will try my best to cover the most important information regarding this contract, but I won't be able to cover it all. So we will try to talk about these 3 main things, and I will answer any questions you have. In this case, I tailored this for a service instead of a product, but you can also have that in a contract, right? What kind of product, your warranty, what kind of liability, how are they going to pay for that product? Is it a payment plan base or 2 payments, maybe when they receive the first load? You know, different types of things when we talk about a product. This time we'll talk about services. So this type of contract ensures that both the client and the service provider understand the scope of work, the terms and conditions of the completion, and the overall cost. As a small business owner, using this type of agreement promotes a positive, transparent relationship that your customers will appreciate. So everyone should be able to understand a well-written client service agreement. Avoid using complex legal phrasing that obscures the contract's meaning for the average person. If you think that your industry has some complicated terms, then I would advise to add those terms to the contract and have it explained. But we want to build something that people understand easily. Very quickly, let me shut my door, pause here for a second. Here I am, very quickly, and I'm going to bore you for a second. I need to talk about the elements of the contract because there is a legal theory behind this, right? What makes a contract enforceable? What makes a contract legally binding, right? How far can you take your contract? So the answer is this: we need to have an offer. We need to have an acceptance of that offer, which we call it a meeting of the minds. It sounds beautiful. We need to have a promise to perform, a valuable consideration, which can be a promise or a payment in some form. And so with those 3 main elements, offer, acceptance, and consideration, we have a contract. We can put it in simple words. You can say, I want to buy that car for $1,000. That's your offer. The acceptance would be, okay, I can sell that car and I will give you the car in exchange for $1,000. So that's fully a contract. Sounds simple, but then when you get into the nitty-gritty of it, it's not that simple. So the next question would be, what should you include in your agreement, right? We see a lot of information. Sometimes we grab a contract and it's 35 pages. No one understands anything. So we want to focus on a few things. It needs to describe the work that you're going to do, right? The work to be fulfilled. It needs to be clear on what is the scope of the project and what happens if you go beyond that scope. Let me give you an example. I've been working with wedding gown and garments designer that needs a contract. And so one thing is the product, the dress that she's promising the bride that she's going to get. But what is the scope of the work? How many alterations does that include? What about the material? Who brings in the material, the bride or the designer? What's the timeline? What kind of deliverables? So we really want to get into the scope of what we're doing, even even if sometimes seems like, oh, why should I explain exactly what my cleaning service is giving if it's just cleaning? Well, maybe we want to say a little bit more. What kind of products I use, and what time of the day is my available time, and do I come with a team of 4 people or is it just myself? So we want to think about all the angles. Of course, we want to discuss what is being given in exchange, which normally we see payment, we see money, right? I give you a service, you give me money. Sometimes we see a service for a service, right? I'm going to trade you my painting services for your attorney services, and we do a trade. Well, we need a contract still. That's the exchange that we need, the consideration. Of course, we need to set forth the kind of law that would apply, the relationship between the parties, right? And what we advise, a dispute method resolution, which what it does is ask the parties to negotiate before they go to a lawsuit, right? To mediate before they call in the bad guys. We don't see this historically because we are a country that likes litigation. But now what we want to do is actually submit the parties to negotiate, to actually have the conversation and get to an agreement before we go to a court of law. The question that I get here, just like when am I ready to register for the LLC, would be, do I need a contract? The answer really is, it depends. Do you offer a service or a product? If you say a service or a product, then the answer is yes. You're like, maybe I need to be serious to have a contract. No, like any kind of person providing a service or a product that thinks that has some liabilities attached to it, some payment plans attached to it, or that you need some sort of definition of what your service looks like. Photographers, landscapers, florists, bakers, consultants, makeup artists, advisors, designers, they all need a contract. They all have rules for their businesses, so they all need to lay that out somewhere in writing. And that's when a contract comes in. In general, what kind of provisions should we include? I put 7 here. They're all equally important and they're not exclusive of each other. We have the introduction to the relationship, the description of services, payment, intellectual property, confidentiality, dispute resolution, and force majeure. So what are those? Let's talk a little bit about them. The introduction to the relationship really refers to who the parties are and having a way to contact the parties, right? We are going to say, Nicole Hetz, email this, phone this, address this. It's going to be the provider, and the client will be this, with email this, address this, phone number this, so the parties know where to find each other. That's the first part. The second part is this description of services, right? What do you do? What kind of services do you offer? And how do you offer those services? You need to be able to write a paragraph or 2 about what you do. Again, even if you are offering cleaning services, and that would be your definition, I'm sure we can come up with some other rules about your business that makes it a description of what you do. Again, if you ever have problems in the future and the parties go back and say, hey, I thought this was included in my service that I hire you, that I pay for, you can go back to that section and actually say, we described the scope of work very clearly, and what you're mentioning is just not there. So that's one way to do it. The payment process and methods. I've seen it all, to be honest. My clients are very diverse. So I see some of them asking for a deposit for when the contract is signed, for example, let's say 50% deposit and 50% at the end of service. I've seen some 15% deposit, a second installment when there's substantial work done, and a third and final payment when the work is actually done and they do like a walkthrough with the client about the service or something like that. So you can choose to do installments, you can choose to be paid at the end of service, you can choose to have a non-refundable deposit, you can choose to have a retainer. This would be the time where you establish those sort of rules. You may find this funny, but this is the section that makes my clients suffer a little bit because they need to think about a way of getting paid, and somehow that's uncomfortable. So when in doubt, ask for a deposit so you can have something up front. So you are reserved in a way for your time and work, and someone on the other side has some skin in the game saying, oh, I put a deposit down, I put a commitment. So that's just a little bit of an advice. Intellectual property. A lot of people gets confused about what intellectual property is. So intellectual property refers to the ownership of an idea or design by the person who came up with it. It is a term used in property law. It gives a person certain exclusive rights to a distinct type of creative design, meaning that nobody else can copy or reuse that creation without the owner's permission. The main question we ask ourselves is, who owns what? In the course of the service, you may develop original ideas like a logo, maybe a business name. So the question is, who owns that while you are under a contract? And this can be solved by including an intellectual property clause in your contract. You will determine what kind of things are owned by who and what will happen with those that will develop in the course of the relationship. This is important for the creators out there, photographers, designers, artists who are constantly creating something new. And the question is, who has the rights on it? I'm a creator, you hire me, I design a couple of logos for you. So is that work yours or is it the designer's work? So that's when the intellectual property comes in time to define this thing. So once I own the intellectual property, how does it protect me? Having the right type of intellectual property protection helps you to stop people from stealing or copying the names of your products or brands, the design or the look of your products, the things you write, make, or produce. You can put a stop on that. The most common example is that it allows you to send a cease and desist letter to those using, for example, the same business name that you have trademarked. So this very good example about this is trademarks, which I will talk about in a second. And so we see in Oregon, we have Stumptown coffee and we have Stumptown t-shirts and we have Stumptown furniture. So how could they all live in the same environment? The answer will be in a second, but I will tell you now that it is because trademark has different classes, 45 of them, and you're only protected under the class you register. So Stumptown coffee is registered under coffee, Stumptown books is registered under books, and so they can all coexist. What happens sometimes with companies like Nike, they go out there and register for all the classes. So you are prevented from even trying to get near the name. So dispute resolution, I mean, confidentiality is a little bit obvious, but if you deal with clients with sensitive information, not to even mention therapists or mental health associates. You want to say in your contract that any information you receive will be confidential and will be maintained that way. Number 6, dispute resolution methods. I mentioned something like this a little bit before. We're all familiar with the most traditional dispute resolution process of our civil justice system, which is litigation and trial with a judge or a jury deciding who's right and who's wrong, where someone wins and someone loses, basically. However, there are many other options available. We have negotiation, we have mediation, arbitration, often called ADR or alternative dispute resolution methods. Whether you are involved in a family or neighborhood dispute or a lawsuit involving thousands of dollars, these processes should be considered. They're often the most appropriate methods of dispute resolution and can result in a fair, just, reasonable answer for both of you and the other party. So if you could guess what percentage of cases actually go to trial, like actual cases that are filed and go to trial in your mind, what would be that percentage? 1 to 100. Only 5%. So that means that the other 95 are using this dispute resolution method. So if you can do anything to avoid the court of law, do it. The last point I want to touch on here is the force majeure clause. What does it mean in French? It means superior force, and is a contract provision that relieves the parties from performing their contractual obligations when certain circumstances beyond their control arise, making that performance inadvisable, commercially impracticable, illegal, or impossible. So in the absence of this force majeure clause, the parties to a contract are left to the mercy of the narrow common law doctrine of impracticability and frustration of purpose, which, let me tell you, rarely results in an excuse of performance. So determining what kind of circumstances will be covered by this clause is essential. The provisions often cover natural disasters like hurricanes, floods, earthquakes, weather disturbances, sometimes referred to as act of God. Maybe you've heard that term before. So we also have war, terrorism, civil disorder, labor strikes, fire, disease, and the most famous of all, COVID-19. So ask yourself, what type of weather-related incidents are common for my location? If there are major disruptions to the transportation systems, will your participants be prevented from attending, for example? What percentage of reduced attendance would make continuing with the service inadvisable? Asking and answering these types of questions will help you anticipate and specify the most critical force majeure events. So a carefully negotiated clause is an important tool for reducing the risk of liability associated with canceling or scaling back a planned event in response to a disaster. This clause became very famous with COVID, of course. A lot of people didn't have this clause in their contract, and when events started to get canceled, when people couldn't go because they turned out to be positive, and so the event from 100 people went to 25, and so the catering didn't work anymore, and the DJ's time wasn't worth it. You know, we start thinking about all these elements that could be solved with a clause like this, which makes It puts a stop in the situation up until the moment where that event will finish, right? In things like COVID-19, we knew that March 13, 2020, it started. But if you ask me, when does that COVID-19 ends? Well, I don't have an answer for you today because I don't know if we're beyond that point. Well, it has been declared by Biden that we are beyond that point, but are we beyond that point? I'm not sure. So this type of clause works as a preventative measure and puts in evidence those circumstances that may happen that are beyond the control of the parties, but that would stop the service in some way. So it's a way to respond to a possible disaster. Let me take a sip of water here. Okay, the third and last topic, trademarks. What are they? And I will teach you a thing or two fun facts about the trademarks. So I talked a little bit about intellectual property and what it was. And when we talk about intellectual property, there are three main rights: trademarks, copyrights, and patents. The three of them are very different. We're only going to talk about the trademarks. A trademark can be any word, phrase, symbol, design, or a combination of these things that identifies your good or services. A common misconception is that having a trademark means that you legally own a particular word or phrase and can prevent others from using it. However, you don't have the rights to the word or the phrase in general, only to how you use that word or phrase with your specific goods or services. You are not required to register your trademark. However, a registered trademark provides broader rights and protections than an unregistered one. So, okay, you came up with a great business name or a great logo, and you want to use it as your company's trademark. How do you make sure you're not infringing another trademark owner's right? And how do you file for a federal trademark application? It all happens with the USPTO, which is the United States Patent and Trademark Office. It's a federal agency charged with overseeing the registration of trademarks and divides the marks into 45 different categories. There are 34 classes for products and 11 for services. So these categories are known as classes and are used by the USPTO to help differentiate and keep track of the many thousands of new marks that it registers each year. So consider that the same word or logo could appropriately qualify as a different trademark in different classes. I gave you the Stumptown example. I can give you the Dove example, right? It's a well-known shampoo and soap, Dove, D-O-V-E, but it's also a popular brand of chocolate, right? So how do they coexist? Well, they're registered in different classes. One would be class 30 and the other one would be class 3. So that could happen. What's important here when we're thinking about a trademark, about a name that we're like, oh, we have this business name or this logo and it's super original. The marks need to be distinctive. So the trademark law only protects distinctive marks. Arbitrary, fanciful, and suggestive marks are deemed to be inherently distinctives. That means original. Descriptive marks, geographic names, and surnames are not inherently distinctive and can only be protected if they can be shown to have attained distinctiveness through use. Generic terms are unprotectable and can never function as a trademark. Once a word becomes generic, it loses all the trademark purposes. So you wouldn't call an apple apple. It's too descriptive of the thing that it is. It's just an apple. You're saying it in the name. But Apple for computers, that's distinctive. That's super original. Who calls an apple to a computer? That makes no sense. Kodak for film, right? Kodak it's an original name for video, for film. So that's okay, that's distinctive. So what protections are available? Why do we really register, right? Why do we take the time and money to do this? So the rightful owner of a trademark can prohibit others from using the same mark or another mark that is too similar in sound, in meaning, or appearance, and it would likely lead to confusion among customers. So every time you use your trademark, you can use a symbol with it. And here's the major confusion in people in terms of like, okay, do I use the TM? Do I use the R? What do I use? So once you actually register the trademark with the federal agency, you can use the R in a circle. In the meantime, you can only use TM or SM if it's services. So whenever you see something out there in commerce with the TM or an R, think of me and say, I wonder if they actually register. And if they have an R, it means that they did and that they invested, and then we can probably find the class, right? So that was a lot of theory. So let me tell you just a few fun facts about trademarks, because if we can't have fun, then who wants this? So, for example, the da-dun sound of Law and Order was trademarked by NBC Universal Media. They actually own that sound, da-dun, right? The orange color on the peanut butter cups packaging of the Reese's wrappers, that background color is a registered trademark. Same with the T-Mobile and that magenta sharp color they have, that's a trademark. The other two funny ones, the phrase, let's get ready to rumble, was actually trademarked and reported more than $400 million in licensing. The last one, the UPS driver's look, that's trademarked, the way they dress. Someone went ahead and formally registered as Pullman Brown. So fun things you can do with trademarks. It gives you rights. This would be like the third step of your business when you're actually serious about your brand and you have a cool business name or a logo, then take the steps to register to trademark your name. Those were beautiful 45 minutes. Thank you for your time. I know it was a lot of information. If you have more questions, contact us. Let's make an appointment. 30 minutes for free. Let's reassess your case and see what we can do. So let's see if we have any questions. Let me stop presenting. Ooh, taxation. What is the flexibility with taxation of an LLC? That is the wrong question for the attorney. I can tell you this. When you become an LLC, you can actually choose to be taxed in different ways. One is as a sole proprietor, which is what we call a pass-through entity, which is in the tax world means that you and your company are kind of the same one thing. And so whatever incomes come through the company is taxed as a person, and it goes. The other possibility that you have when you're making a reasonable salary, meaning enough money to pay yourself, a reasonable salary, you can become what we call an S Corp. And again, an S Corp is a tax election, not an entity type. The LLC is the entity type. The S Corp is when you are making enough money and you want to take advantage of your taxes in a different way. ask for an accountant or a CPA, you have to get a consultation with someone who's going to teach you how to take advantage of this. If not, it's not going to work. A lawyer is not going to tell you about taxes. We avoid it at all costs. We don't want to talk about taxes, but there are definitely things to learn about it. So please set up a consultation with someone. Okay. Veronica, where is the trademark usually located? Because I want to use a hummingbird in my logo, and in some social media, just the hummingbird alone as my logo in my social media. And I want to make sure it is not copied from someone else's. Great. The way we do this as a firm is we separate the trademark process in 2 steps. The first step is the viability search, and the second step is the actual application of the trademark. The first step, the viability, is research in the trademark data and online and everywhere else to see if anyone else has registered anything, the same thing or something similar that could be confusing with what I'm trying to create. So that first step would clear those doubts that you have in terms of like someone else using the hummingbird and how to prevent others from copying. Maybe with all the love in the world, you are the one copying. So, we want to make sure to, before we create, we check if anyone else has something similar. So what some people do is put like a watermark on their images, up until the point where they try to copyright the image instead of trademark the image, which is not the same. If you want to use an image for a logo, that's a trademark. If you want to use an image as a design, that's a copyright. So that would be my first question. I would do the viability search to clear any doubts on the hummingbird issue and see if anyone else has something similar before I invest in my brand, before I invest on putting my name and logo out there. You will ask, can regular people check this? It's a little bit complicated because this is a system from 1981 and they still want you to fax things. But if you have the time, you can search in that website, a basic wordmark search, for example, and it will give you a couple of results. Look at it. It won't be the same as me doing research for you, but you can have some fun there. Any other questions that I can answer for you today? That was like a lot of information. I'm sorry. A lot to pack in there. And again, you can always set up a short conversation with me to talk about your specific case if you don't want to talk about it here. I'm happy that you listened to this information. And if anything, I would like you to get out of here thinking that, oh, if I'm serious about my business, I should consider an LLC and I should have a contract laying out how I provide my services. And if I'm really serious about my brand, then I'm going to invest in trademarking because I don't want anyone copying what I'm doing. So those are the 3 things I want you to take home with you today. Vanessa. That's a hand up.
It looks like Vanessa did put a question in the chat, and so did Kirsten.
I see now. Is it good enough to have my terms and conditions on this use and what's needed by the client on my website or a contract? Vanessa, according to what you're saying there, you are providing a service. In the description of services, we would talk about what kind of things you set up for the website, what kind of email marketing, SMS campaigns. We will have to lay that out. And sometimes the terms and conditions are not the same as a contract. The terms and conditions are for the website itself, not focused on the service itself. So they are a little bit different. I would build a contract for your services and separately would do the terms and conditions for the website and how the website works. And if you are collecting any kind of data, right, any privacy policy that you have there. But definitely you need a contract. Kristen asks if the steps to get woman certified are worth the effort. You know, that's a hard balance. Some of my clients pursue different certifications, women-owned, BIPOC-owned, Benefit for Good Corporation, NGLCC, you know, different certifications to kind of boost their image. So it's a little bit hard to measure if something like that is worth the effort. It depends on the kind of people you want to attract. For example, I am married to a woman. I support gay rights. If I see any businesses that are NGLCC registered, I may support them. So if you want to attract that kind of people or a specific section of the population, like women, go get that certification, put in the effort, because it helps you to network. It helps you to put your name out there. It's a plus. I see that Naomi put in the chat the form that we usually use for new intakes. If you're interested in getting a consult with me, fill out that form, let us know what you have going on, and we will get you in the schedule so we can talk. What is the base cost in getting a logo trademark? You know, the ranges vary depending on how many classes and what your application looks like. You are normally seeing between $800 to $1,000 to apply from 1 to 2 classes. Yeah, because you have filing fees, those are government fees, and legal fees to actually do the work for the application. So yeah, it's an investment, and sometimes it's hard for clients to realize that it's not a tangible thing. A right is not a tangible thing, but when you're building a brand and you're investing in something, you got to get the rights to it. So that's the formal process. It's a one-time fee for registration, and then you have a fee for in year 5, in year 7, and in year 10. And I believe it's $100 each time. It's like basically you saying to the USPTO that you're still using the brand in commerce, because if not, they declare it abandoned and they make it available for other people to register. You know, they don't want to reserve a name that someone else could take advantage, possibly in the world, and register. So that's why there's an ongoing fee for year 5, 10, etc. I'm sorry for my dog. It's talking in the background. I have a construction happening. I'm glad you didn't hear it, hopefully. Also, I want to say thank you to Luis, who came twice. We did this presentation 2 weeks ago about entity formation. So thank you for coming. Good to see you. And if you need to get on a consultation, do the intake form. We will chat. I'm happy to chat with you.
All right. Thank you so much, Nicole, for being here. Does anyone have any last minute questions before we wrap it up? The recording will be available to everyone. It'll also be on the website. If you'd like to receive it in your email, you can just reach out to us. Again, I put the contact us link in the chat for Rational Unicorn Legal so that you can schedule that no cost 30-minute consultation with Nicole. We're so grateful that you were able to join us again this afternoon, and we hope to see you all again next month. Thank you. Thank you so much.
Thank you so much, everyone. Thank you for your time. I appreciate it. And thank you for listening to me. Thank you. Thank you. Thank you. And good to see you, Naomi. Good to see you, Jesse. Bye-bye.
You too. Thank you. Bye.